Hello, everybody. We're going to get started today. Welcome and thank you for joining us today for our lunch presentation on Destination USA. When a Canadian company provides freight delivery services to the US bound goods or deliver product to US customers in their company-owned vehicle, they could be opening themselves up to federal and state tax liability. So today's webinar, we're going to discuss these types of activities and how they could impact the businesses. I'm Carolyn Powell. I am the Development Director here at Tronconi Segarra and Associates. I will be your host today. There's a couple ways that you can engage with us. There is the toolbar on your screen. There's a copy of the handouts and presentation is in there, and also David's bio. There's also a question section. If you have a question throughout the presentation, feel free to pop a question in there. After the presentation today, you'll be receiving a survey and you can give us some feedback if this was helpful for you, if you had any additional questions, or if you would like to set up a time to talk with David directly about your specific situation. I will also send you an email this afternoon with a copy of the presentation and a link to the recorded version if you want to go back and re-watch anything. So without further ado, let's get started. Tronconi Segarra and Associates is a certified public accounting and business consulting firm. David Lever is a CPA and partner here at the firm with over 16 years experience in public accounting. David is part of our tax department and focuses on foreign-owned companies doing business in the US and or having facilities in the US. He understands the complexities of being a foreign owner and the business difficulties between the countries. So I'll hand it over to David for us to start.
Thank you, Carolyn. And thank you for joining us today on the next presentation in our series here about doing business in the US. So what we're seeing more and more is that businesses are selling into the US, whether it be remotely or through company-owned vehicles. And just to give you a little bit of a sense for just how busy, specifically in the Buffalo Niagara area, it is. I mean, the US-Canada border, again, with our countries being so close together, there's a high volume. You can see this on the chart of trucks, which really dwarfs rails over the years, coming into the US. And the Buffalo Niagara region, of course, is one of those highest areas. So as you can see here over this is some data from the customs, and you can see that Buffalo Niagara is consistently second or third in truck containers that come across the border. I was finishing second to Detroit or the Michigan area. So there is a high volume. There are a lot of companies that are doing this, and we're going to go through some of the concepts at federal and state-wise. A little bit of this will be a bit repetitive with the last presentation, so you'll have to indulge me in that, but we'll get right into it. So for foreign companies that are doing business in the US, we're always talking about the concept of permanent establishment and income that is effectively connected with the conduct of a US trade or business. The effectively connected income being our statutory regulations in the US, doing business in the US. The US-Canada tax treaty provides that business profits are subject to US federal income tax if that permanent establishment is created. And so specifically, because we do have such a robust treaty with Canada, we have Article 8, which is the transportation article, that says that goods and passengers transported from outside the US into the US does not in of itself create a permanent establishment. The key here really is the backhaul services. So if your company is returning goods back from the US after they've delivered the goods into the US, that would constitute a permanent establishment. Of course, point-to-point trips within the US also create a permanent establishment. This also covers the rental of containers, ships, aircraft, and then interestingly, which maybe don't see as much, but rental of railway rolling stock motor vehicles. They are subject to a test of 183 days in a 12-month period. And also interestingly, because of our border with Mexico, I looked at the Mexican-US treaty as well. The benefits afforded under that treaty are not as helpful or as robust as the US-Canada treaty, where they do not allow for the backhauling to be a protected activity. So any type of trips going in or out of Mexico into the US would be taxed under the US-Mexican treaty. So if your company has a permanent establishment, if your company does not have a permanent establishment under the tax treaty, there is a little bit more housekeeping that we need to do in order to protect your company. That would be to obtain an employer identification number with the IRS and to file what's called a treaty-based tax return, a protective treaty return Form 1120-F with the IRS. And basically, this return just says, hey, IRS, I've been shipping product and transporting product into the US from Canada, and under the US-Canada tax treaty, we'd cite that Article 8 of the transportation article, that activity in of itself does not constitute a permanent establishment under the treaty. In IRS, you cannot tax me. And so this would be an annual filing. We would disclose informationally how much your sales were into the US. Any other activities that we'll talk about a little bit that might be ancillary, but not create a permanent establishment. And then we would file that return. And what that return does is it gets the statute of limitations started. It avoids future penalties and interest. I talked about it in the previous presentation. There was a court case involving a company that thought it did not have a permanent establishment, but did not file any tax returns. And lo and behold, the IRS contended that they did have a permanent establishment. Because they had not filed any return at all with the IRS, upon in tax court, the IRS won and it actually taxed the company on its revenues, and that didn't allow expenses because so much time had passed. So it's just a really kind of a conservative and belts and suspenders approach that we like to take with our clients to prepare that treaty-based tax return and to make sure that at least that we can mitigate any exposure, especially if we're in a situation where it may not be clear whether you do or do not create that permanent establishment. So if your company, does have a permanent establishment, it's not the end of the world. A lot of companies do operate through what we would call a branch, or they might be using this approach to test the waters in the U.S. or depending on the facts and circumstances. It may still be a beneficial way to operate in the U.S. And I know we did talk about that in the prior presentation again, so I'm not going to get into the pros and cons of some of those things in this presentation. But if the company did make that decision to operate through the Canadian company, they'd still have a tax number, the EIN with the IRS, and then we would report a branch return on Form 1120-F, and we would then identify the revenues and expenses that came from that activity. I always like to think of it as a division of your business. So we look at the division of your business that was operating in the US, identify the direct revenues and expenses related to that activity, and then make an allocation of other support services or other costs that are being incurred by the company, maybe in Canada, that we can allocate to the activity that are related. And that would generate the corporate income tax that is due at a 21% tax rate currently to the IRS. The Canadian company would file a tax return on in the same time frame as a normal US business, US domicile business. So 3.5 months after the year end, so April 15th for calendar year filers for that tax filing. Any tax paid in the US would be eligible for a foreign tax credit in Canada, so it wouldn't necessarily be a double tax situation, just maybe a little bit more complex Canadian tax filing for your business in Canada. And then we have this concept of the branch profits tax. So the branch profits tax is the deemed dividend. The US tax system is very similar to the Canadian tax system. Two layers of tax on the business, the first being the corporate income tax, the second being the dividend tax. So in this situation, because the company is not domiciled in the US, we would always look at the activity in the US. So to the extent that the company was not reinvesting the profits from the US activity into the business and taking those profits back to Canada, that triggers the deemed branch profits tax, which is 5% of the US-Canada tax treaty. Like I said, can be deferred if the profits are being reinvested in the US activity. However, the first $500,000 in Canadian funds, so we do a translation, can be sent back with no branch profits tax. So this is again another benefit of the US-Canada tax treaty that's kind of unique. So again, it does allow your company to test the waters in the US, and some companies continue operating through this branch approach, and others may make other decisions to further expand into the US. So there's a couple areas here that I'm going to touch on next, on this next couple of slides, more as a recognition thing. A lot of the companies that are in the delivery business are already aware of these. These are not, I would say, heavy areas in which we deal with it from on a daily basis. But going to this topic and thinking about what some of the relevant points would be for the audience today, I thought we'd be kind of remiss if we didn't include these items. So the first is the federal heavy highway use tax, which is an excise tax administered by the IRS on heavy vehicles that are on the roads, on the freeways in the U.S. So 55,000 pounds is or greater gross vehicle weight, and so this is required when a heavy vehicle is registered with the state, and that is the stamped IRS Form 2020-90. My understanding is it's also enforced in Canada as well. So the reporting for this, and really just it's an annual fee. So if you the July to June reporting year, so if you put a vehicle into service in that first year, you may pay a prorated fee, and then every year after that, then you pay an annual fee based on the amount of miles, that you're going to be driving in the U.S. So the initial filing is due 1 month after the new vehicle is put on, so on the public highway. So you may, if you have multiple vehicles, you may have to have additional supplemental filings after your annual filing if you do put new vehicles on the highways. If your vehicle is going to be used less than 5,000 miles during the year, you can have the tax suspended and not have to pay the tax in that year until you're going to exceed that threshold again. And then the second is the IFTA, the International Fuel Tax Agreement. This is an agreement between the 48 states, contiguous states in the US and Canada, and the weight threshold is a lot lower than the heavy highway use tax. So 26,000 pounds of gross vehicle weight or more that are crossing into or more member states. So you can see the diagram color-coded in the regions. And this is, again, something that's licensed and decaled, and there's quarterly reporting. And really what the purpose of this system is really to avoid trucks and companies from just filling up in the states that they know have lower taxes. So this is kind of a tax sharing agreement amongst the states where you'll report the mileage that you incurred in each state And we're going to see that as we go further into the presentation today, that being able to track the mileage, is important in these situations. I know in a lot of the situations that may be a basis for how fees are derived, so I think it's pretty common. But in this situation, the fuel taxes that vary from state to state are kind of equalized amongst the states kind of through this process of, okay, well, I'm driving in this many miles through this state, so they're going to get so much in fuel taxes. So moving on to state and local taxes, one of our favorite areas here at TSA. Inbound businesses are that may be advised that they have treaty protection, as we discussed under the U.S.-Canada Tax Treaty, may not have protection for state and local purposes. And in most cases, they do not. The treaty only applies to U.S. federal income tax, and the 50 states have the ability to choose whether they want to follow the treaty or not. In most cases, they do not, or there's some modified version of that. So a foreign company could have state and local gross receipts taxes, income tax, of course, possibly sales and use tax, potentially, depending on the business, also property and payroll, depending on your business involvement in the U.S. So we're always talking about nexus, and I think nexus gets a lot more press than permanent establishment, but nexus really is the connection that a taxpayer may have to a state. So it's a link, a minimum connection for a state that is seeking to tax it. So states have gotten a lot more creative over the years for different types of taxes. So we have really 3 different types of nexus. We have physical presence nexus, which is the traditional nexus, you being physically present in a state, your company having employees, having property, payroll, those types of things. Economic and factor have come in more recently. Economic is more, and we'll, actually, we need to go to the next slide. I'm sorry, Carolyn.
Oh, sorry.
Yep. So economic nexus is based on an economic connection to the state. This tends to be a little bit more vague. Some states have some bright line tests regarding economic nexus, but a lot of them have very vague statutes that say that if you're doing business in our state through various means, that you have nexus there. And then the factor presence nexus, again, that is more of a bright line test as well, that we're seeing more and more as states try to tax companies that are doing business from remote places. So the other protection or the other consideration here as we evaluate your situation is about whether your company has protection under this Public Law 86272, which prohibits states from imposing net income tax on income that's only within their state or helps to govern interstate commerce. So originally this law was really meant to protect salespeople, kind of traditional salespeople, the way we think about it. You know, if you were set up, if your company was based in New York State and your salespeople traveled to Pennsylvania and Ohio and other neighboring states, that you wouldn't necessarily have a filing obligation in those states and have that physical nexus created unless you did something more than just soliciting sales. And so in this case, based on when this was written in 1959, it was for mere solicitation of tangible personal property. So services, digital property not included. And then the salespeople were limited to what they could do. And so orders had to be approved from outside the state. Fulfillment or shipment or delivery was from a point outside the state. And as we'll get into again, this protection may not be afforded to companies based outside the US or foreign sellers. And so, you know, it's really important here, and you may think specifically in that situation, 86272, and the topic today being shipment and logistics, does my company, am I covered by that? And we'll get to that in a couple of slides. So we have all these different factors, different rules that we're considering here to determine whether my company has a state filing obligation. And unfortunately, as we find with most state things, you know, it's not clear cut. So you might think, okay, well, does my company have Nexus? And then usually the second question is, well, do I have to collect tax on this? And the answer to that, as we like to say, especially in the salt world, it really depends.
Never that straightforward.
Which is why this presentation is an hour and not 30 minutes.
Right.
So in this situation, we have to look specifically at what your company is doing, especially in the case of a logistics company. If your company is, depending on how your contracts are structured, so oftentimes for all companies that are using subcontractors, that typically creates a nexus for them. So if somebody's delivering on their behalf, or that's not a contracted care, like a postal service or just a freight company. So oftentimes if you're rendering a service and somebody's doing it on your behalf, it still creates a nexus for you. So in the case of logistics companies, the arrangement that you may have with your customers may impact this. So questions come up: does your company bear the risk of loss on the delivery? Are you acting more as a intermediary between your company and the customer and the actual company doing the shipping? So it really depends on your role in the process with the client, and are you taking title to these goods? Are you what is the kind of legal arrangement first? Because oftentimes having property in a state does, or even flash title can create nexus. And then I wanted to provide this chart as well to provide a little bit of background. But before we get into the actual chart, I do want to note, I do have a couple of these charts in the slides today. And while they are visually easy to use to figure out where you might be, the questions are pretty specific. And oftentimes, as we find in the state and local area, you do have to drill down on some of the details. So for example, in this illustration, the question here is, if an out-of-state business makes deliveries into the state using company-owned trucks, will that activity be protected under E6272? Or will it create nexus for the company? In this case, it may be possible that this could be a protected activity for your company if you're sending, if you're delivering your goods in company-owned trucks. But then there are other considerations. One, does the state afford the A6272 protection to your company? If you're a foreign company, there are many states that do not, like California and New Jersey and others. And then also, as we'll see on other slides as well, it sometimes can come down to more of the specifics with regards to, are you doing any more ancillary activities? So, there are some A6272 traps, right? So if you're sending your product, and we see this often too, especially if a company is selling something that is customized or maybe has specific needs for how it's cared for, right? You don't want to use a regular freight company. There's whether it be temperature control or special handling and care that's required. You may want to send your truck with your people who know how to handle the product for delivery. And so the best answer still may be for your business to use your company-owned trucks. But if your employees that are making the delivery are doing more than just delivering the product, such as installation, commissioning, repairs, or things that are ancillary to that. They could be doing training. Sometimes you see situations where they may pick up if there's warranty work or something that needs done on a product. They may, again, they're going to do what makes sense, right? They're making a delivery to a customer, and that customer, another customer close by is, you need to pick up something for warranty work. They may pick it up on the way back, but doing those extra activities can blow the 86272 protection. So the other thing to point out here, again, with state income taxes, even if you do have the 86272 protection, your company may be subject to minimum taxes, alternate base taxes, these non-income based taxes that states have started to employ in order to kind of get around the 86272 protection, because again, on the previous slide, it is only for income-based taxes that are levied by the states. So even though sometimes these, it's a nickel and dime type of thing, especially in the case of the state minimum fees and franchise taxes, we may be covered for the corporate income tax, but you may be subject to an $800 minimum tax in California, $700 here in New Jersey. It can add up quickly, especially over time, if you haven't filed or are not aware of your obligations. The other items that are listed here, the Ohio CAT tax, Texas margins tax, and Washington B&O tax, especially the Ohio and the Washington taxes, those can creep up on you as well, because those are gross receipts based taxes, especially Washington being only $100,000 threshold of sales into the state in order to be required to file. So, and those are gross receipts taxes. So even if your company is not profitable in a given year for a particular reason, or the margins aren't great, or you're just starting out, and you haven't really gotten off the ground yet to get kind of the critical mass to be profitable, Washington may still want that tax on every dollar of gross receipts, and they don't really care whether you're profitable or not. So one of the other things that's specific to this area is how we compute the tax. So the traditional state formula for computing state income tax is to start with the federal taxable income for the year and then to apportion the income. Most states use one factor apportionment now. Used to have three factors: property, payroll, and sales. With the way things have gone, the economy in the last 10, 15 years, a lot of states have gravitated towards just the sales factor in determining the taxable income in their state. So what ends up happening is you figure out the federal taxable income, you determine how much are my sales into that state, and whatever percentage of sales into this are going to the state, that particular state, that percentage of the profits for the year are the basis for the state income tax. And so, this is important. The state taxation is also unique for foreign companies. Some states you might say, okay, well, what if I'm covered under the treaty protections? Do I have, what is my basis for starting the state income tax calculation? Some states, there's really three different treatments. Some states say, we'll follow the treaty, we'll follow whatever's on the federal tax return. So if you're covered under the treaty, you may not have a state obligation in that state. Florida is an example of that. Illinois, another example. So in some cases, you may have no income tax in that state because 0 is your starting point. You may have to pay a minimum fee if the state employs one of those. The other two types really are the worldwide approach, which is the California approach, New Jersey approach. So if you're doing business in those states, which is pretty frequent, we would compute everything based on everything that the worldwide income of your company. We'd translate your Canadian financials into US dollars. We would look at, okay, well, what are your sales into California and what are your sales worldwide, and compute the tax on that basis. States like New York, Pennsylvania, and most others, and this is probably the most frequent, use that effectively connected income. So we basically create a federal tax return and on US tax rules if the company was doing business in the US. So we create this federal tax return that doesn't get filed with the IRS. And from there, we apportion based on, okay, well, what are my New York sales compared to all my US sales? We just look specifically at that effectively connected activity and use that as the basis. So in this apportionment formula, to take it one step further, if that's not already confusing enough, there are special rules for trucking and transportation companies. So many of the states that employ a single sales factor switch to a 3-factor, and others that have 3-factor switch as well. So some of these are specific to, like Arkansas, for example, has a 3-factor formula for transportation shipping companies, even though typically they use a single sales factor. You know, and some of the reason for that really is because we know that you're employing property and probably payroll in their state, that they really want to try to drive up that factor. And so that's just something we also need to consider when we're figuring out what your state liabilities might be. So mileage is important. I know I mentioned earlier, mileage is probably the most common variable. You might say, okay, well, I've got a sale for a shipment from Ontario to Florida. Do I have to file in all these states? Again, that's where we kind of get into, unfortunately, it depends, and where you might need to look at what are the state rules. Is it destination based? Is it origin based? That's the market based and cost of performance area. But then also the mileage. So the mileage is, you know, important as well. Many of the states use that special apportionment. So we would use the mileage to determine the sales allocation. So we would look at the mileage in each state and use that to determine what percentage of, what is that sales factor that we're talking about where we're trying to compute your state income tax. So again, to be able to track, and I know this is usually pretty standard amongst logistics companies and shipping companies, but for the companies that are especially using company-owned vehicles, it's important to be able to track the origin, the destination of the shipment, and the mileage as well, state by state.
I think we just added another column to their spreadsheet of tracking that we're always telling them to do.
Exactly. So here's another one of these charts. This is based on delivery services. So to address the second question about delivery services and whether they're taxable, again, these charts aren't the be-all end-all. They are good to start, as good as a good starting point. This specific chart about delivery services sales tax has more specifically due to with a actual delivery service, and if that's the only charge. So oftentimes this may not really apply to companies that are delivering their products, because there may be a delivery charge that goes along with the sale of the product. That is in most states tied to whether that product is taxable or not. So if the product that you're selling is taxable in the state, I know we've had other webinars from the sales tax folks on some of those issues. If that product is taxable, the delivery charge may be taxable. Whereas if the product is exempt, the delivery charge may also be exempt. This chart really more or less says, okay, well, if my company is just providing the delivery service, do I have to charge tax on it? And in most cases, that is not the case when it's just purely a service that's being provided. So for the last half an hour or so, you've heard me ramble on about all these different areas, especially in the state where it's definitely not as clear cut as from a federal perspective. You might think, okay, well, what can I do for my company, and what do I need to really think about here? So oftentimes, especially in Canada, we see different companies set up for sometimes to house employees in them. Other times, I've seen companies set up just to have the vehicles, and some of I know this stuff from a liability perspective as well. So you might think, okay, well, I'll just create a separate company for my vehicles, and they will then will insulate the Canadian company from having much state liability, right? Even if I'm going to be using my company vehicles. That can work in some situations. In a lot of situations, it does not. A lot of states employ unitary taxing concepts, meaning that if you have commonly controlled business enterprises that are doing business in a state, they may not look at just your delivery company. They might want to look at all the companies that might be doing business in the U.S. and tax on that basis. Again, another strategy, the use of a third-party common carrier. That usually does, especially in the case of company-owned company sales and using delivery, the use of a third-party common carrier in almost all cases does not create nexus for your company. So if you're using FedEx or other freight companies to do delivery and they're just delivering, that's fine. Again, there may be reasons and good business reasons why you may want your truck to come to be the one making delivery with your people handling it, who have some specialized knowledge or some special care for your product. And then, you may have, again, unintended nexus created for other divisions, business lines. So the economic nexus, factor presence nexus still may apply for your company. So, you may be delivering something into the state or having your company vehicles come into a state, and that specific charge, that specific activity may be covered under the Public Law 86272, or it may be something that's non-taxable. We always have to think about the other implications on your business. If that's only a segment of your business, if you're physically going into a state like that, and it is covered for one of those reasons, it may open up kind of Pandora's box on if your company is also making remote sales into the state, they may be selling product online that gets shipped in a different manner. By creating that nexus, which may be kind of benign in that specific situation, you may be opening up other lines of the business. So you have to collect sales tax, or again, you may have some other concerns with state income tax nexus as well.
All right, that was a lot of good information, David. There's one question. Does it depend on who owns the goods during the delivery? Is the customer paying for them upon delivery, or do they pay for them in the pre-delivery? Does that change any of this, or does it really just not matter?
Unfortunately, I think it does depend a little bit, but at the same time, it may not. I think it would definitely depend on your business's role, right? If you're the company making the sale, typically the customer is not going to want to take title to that until you deliver it to them. So that's probably your obligation. It gets a little bit murkier, I think, in the situations for the logistics companies when it comes to regards to, right? Because your role in that really is to create or arrange for the freight or arrange for the delivery, and the customer may or may not be taking title there. But some, like I said in the slides, in some situations, we just have to kind of figure out what's your role in it, what is your legal role in it, and for what we call it the flash title, you may for a short time be responsible for that, for those goods. And even if you're not rendering that service, depending on how you're doing it, and may still give you a physical presence in the state.
Okay, great. Hopefully that answered your question there, Jim. Just want to wrap things up. If you do have any questions, throw them in the question box and we'll still get them answered for you. Again, there will be an automatic survey coming out to you as soon as we finish today. So if you'd like to talk with David one-on-one about your situation, you can do that. Our next webinar will be March 12th. We'll be discussing sales tax audits, managing the process to minimize liability. So it's kind of a continuation of this topic, and always a good topic that people need reminders of, and you never know when that audit's going to show up. So
Carol, I think we did have one more question too. I think
Oh, great.
sitting up here on the screen. What is the ramifications? Do I need to file a treaty-based tax return if I'm only sending my trucks into the U.S. for once or twice a year? So that is a great question. So when it comes to the permanent establishments, I know with the state income tax, we have a lot of thresholds, whether it be $100,000 or certain activities or certain times. Unfortunately, with the treaty concerns, there really is no de minimis under the permanent establishment articles of the U.S.-Canada tax treaty. So oftentimes, and it is like this really in a lot of different situations, whether it comes to be the federal tax or the state taxes, our role in the process really is just to provide the company with information to make informed business decisions. If your truck is coming over once or twice a year to make a delivery, we may have to look at that and say, okay, well, yes, under the letter of the law, yes, you're operating a U.S. trade or business, and then we need to look at probably some more of the specifics because probably what's happening if you're sending your truck over, there's probably more sales that are happening anyway. So it's probably part of a larger conversation about what your company's activities are in the U.S. And so oftentimes we see these treaty-based positions being filed for multiple activities in the U.S. Part of it might just be my sales are X into the U.S. I don't have any physical presence. Others might be, okay, well, I'm selling to the U.S., but I'm also rendering a service. And then there's separate rules for that, or in this case, the transportation article. So there are oftentimes companies that maybe find these treaty positions for 1, 2, or 3 different activities within the context of their business. It is possible that one of those could be considered to be a permanent establishment, but another could not be, depending on the specifics of the contract, the situation, especially in the rendering of services. So it is really important for you to take a look at that again, because that is a protective item for your company. And again, we always say this, in a lot of situations, just because everybody thinks, well, if you create a permanent establishment, like that's the be-all and end-all of the world, and it really isn't. It can be used strategically to test the waters in the U.S. Or we wouldn't want necessarily to get in the way of a good business opportunity. Again, if you're in a situation where your company sells a specialized product, a product that might need to be temperature controlled or have special delivery requirements, it may be just in the best interest of you and your business model to use company-owned vehicles. There's nothing really wrong with that. We just need to be able to quantify what the requirements are for your company to make sure you're on side with the rules for the IRS and with the states. But again, our role in this really is just to advise you on the situations and then help you make informed business decisions with regards to where I need to be compliant and what I can do to protect my company from double taxation or taxation well after the fact.
Great, thank you. Great question too. So thank you everybody for joining us today, and we will be in touch with you, and hopefully we will be talking with you on March 12th for the next webinar on sales tax audits. Have a great day, everyone.